Dear students, today we are going to discuss guardians and their powers under Muslim law. Muslim law recognizes four kinds of guardians. The first one is natural or legal guardian. These terms are used interchangeably. They are called natural guardian, they are also called legal guardians. The second kind of guardian is testamentary guardian. The third one is guardian appointed by court, who is also known as statutory guardian. And the fourth one is de facto guardian. Now let us try to understand what do they mean one by one. The first one is natural or legal guardian. Natural guardian is a person who has a legal right to control and supervise the activities of a child. So he is the one who has legal right to control and supervise the activities of a child. He has got a very special relationship with the child. And because of that special relationship, that person, that means legal or natural guardian, has a legal right to control and supervise the activities of a child. Muslim law recognizes father as the natural guardian of his child under all schools of Muslim law. Father is recognized as natural guardian of his child under all schools of Muslim law. But father alone is not the natural or legal guardian. There are other people also. For example, if you look at the sequence that I have given in the order of priority, the first one is father. The second one is executor of father. The third one is paternal grandfather. And the fourth one is executor of paternal grandfather. Now, you might be thinking, what does executor mean? So let me tell you what it stands for. Executor is a person who has been appointed under a will, under a wasiyat. Suppose father has appointed him under his will, then he is father's executor. If a person has been appointed by paternal grandfather under a will, then he is executor of paternal grandfather. So this is the order of priority. In this order of priority, natural or legal guardians have been recognized under Muslim law. But there is a difference. Under Shia law, in the absence of father, only paternal grandfather may act as natural guardian. What does it mean? It means that Shia law recognizes either father or paternal grandfather as natural guardian. None else is recognized as the natural guardian. There are only two persons, father and paternal grandfather. However, the earlier list is according to Sunni law. Sunni law recognizes other people also, but Shia law recognizes only father and after him paternal grandfather. The second and next category of guardians is that of testamentary guardian. The second category is known as testamentary guardian. Testamentary guardian, the word testament means will, wasiyat, legacy. So if anybody has been appointed under a testament by a competent person who has the right to appoint, then that person, the appointee, is known as testamentary guardian. So testamentary guardian is a person who is appointed as guardian of a minor under a will. Under a will. That is why such a guardian is known as testamentary guardian, because he or she has been appointed through a testament. Will is also known as testament. That is why this word is used, testamentary guardian. But who has the power? Who has the power to appoint testamentary guardian. Only two persons under Muslim law have the power to appoint testamentary guardians: father, or in his absence, paternal grandfather, has the right to appoint a testamentary guardian of a child. So only two persons, either father or paternal grandfather. But for being appointed as a testamentary guardian, there are two requirements. And those requirements say that the person who is being appointed as testamentary guardian must be an adult and sane. What does it mean? It means that he must not be minor. He must not be insane, he or she. Now, here something must be remembered, something must be understood, and it is very important. In earlier category, natural legal guardian, mother is not mentioned. So that means mother is not a natural guardian according to Muslim law. For some people, it may appear to be discriminatory. Obviously, it appears to be discriminatory. A mother is not then treated to be natural guardian, but she can be appointed a testamentary guardian. So, according to Sunni law, even a non-Muslim or some other female, including mother, may also be appointed as testamentary guardian. Sunni law says that even a non-Muslim or a female may be appointed as testamentary guardian. But Shia law is different on this point also, and it says that a non-Muslim cannot be appointed as a testamentary guardian. The third category of guardians is of those people who are known as guardians appointed by court. And as you know, when we were studying Hindu law, probably I had discussed this thing at that time also, and same law applies on this point on both Hindus and Muslims and other communities also. In the absence of a natural and a testamentary guardian, the court is empowered under the Guardians and Wards Act 1890 to appoint a guardian for the protection of minor's person or property or both. So who appoints? Court appoints. Why? Because there is no natural guardian, there is no testamentary guardian, and the child needs a guardian because child is minor, is still a minor. A minor is supposed to be immature. A minor cannot take care of his own person. Minor is supposed to be immature to take care of his property or both. Therefore, he needs somebody's care, somebody's guardianship. So, in this situation, when there is no natural guardian, no testamentary guardian, the court has the power to appoint a guardian. Such a guardian is also known as a statutory guardian because such a guardian is appointed under a statute. And what is the name of that statute? You must remember the Guardians and Wards Act 1890. There is fourth category of guardians. In almost all laws, this term is used, including Hindu law and Muslim law. That guardian is known as de facto guardian. The word de facto means in fact, वास्तव में, actually. So this de facto guardian is not a natural guardian. He is not a legal guardian. Neither he has been appointed as a testamentary guardian, nor he is a statutory guardian. But he has himself assumed the custody and care of the child. On his own, he has got a special relationship with the child. Such persons are generally close relatives of children. In many situations, what happens, the when the child becomes orphan because of the death of parents or because there is nobody to take care of in the close family, some other relative, mama, mosi, bua, chacha, chachi, they start taking care of such a child who needs protection. But such relations, which I just mentioned, they have not been mentioned as natural guardians, and they have not been appointed under testament also. But they assume this duty of the custody and care of the child. It may be said that a de facto guardian is a person having no authority for the guardianship, but under the circumstances has undertaken the responsibility to act as the guardian of a minor. So they themselves have assumed, under the circumstances, the responsibility to act as the guardian. So this kind of guardian is a very weak kind of guardian from the point of view of powers of the guardian. Now let us try to understand guardianship of person. What does it mean, and who are the persons who are said to be the guardians of person? What exactly it means when somebody says that Mr. X is the guardian of person of a particular minor? What does it mean? It means guardianship of a minor's person is the overall supervision of the minor's personality. Overall supervision of the minor's personality. It means, under inverted commas I have written, it means care and welfare of the child, including the liability to maintain it. Liability to maintain it, this must be remembered. Guardianship is not just a right, but it comes with liability. And the liability is to maintain the child. The right or power is to take care, to do all those things which are for the welfare of the child, but there is a liability to maintain the child also. It is more than simply the custody of the child up to a certain age. It does not only mean that guardian has the right to have the custody of the child, physical control. Child is a human being. Child is not a thing. Therefore, he should be treated differently, unlike non-living things. He is a living person. Therefore, it is not just a matter of custody. The child needs care. The child needs protection. The child requires welfare mechanisms through with the help of which the child can grow up, get a mature person, a responsible person in the society. He has many requirements, for example, maintenance. Therefore, all these things are included here. So, the guardianship of person means care and welfare of the child, including the liability to maintain it. Under Muslim law, guardianship of minor's person means sharir. Guardianship, that means body. Guardianship of minor's person is called vilayat-e nafs. It's a difficult term, but if you will practice, you will remember it. There is a difference. Guardianship of minor's person is known as vilayat-e nafs. However, the custody of the minor is called hizanat. These two terms you should try to remember. Vilayat-e nafs and hizanat. These are two distinct things, different from each other. Vilayat-e nafs means guardianship of minor's person. Hizanat means the physical custody of the minor. Vilayat-e nafs is the right of the father. And in his absence of other legal guardians who have been mentioned in my first slide, when I was explaining natural guardian. So vilayat-e nafs is a right of the father, and in his absence, other natural guardians. However, hizanat, that is physical custody, is the right of the mother up to a certain age of the child. This is what I wanted to highlight. Mother too has a right, a very special right. The right of hizanat. That means up to a certain age, the child must be under the custody of the mother. Under the custody of the mother. There are certain very fine points which must not be forgotten. And what are they? What are those fine points? The mother has the right to the custody of her child, the right to the custody of her child, which is known as hizanat, for a specified period of time. Why? Because except her, no one else can nurse and handle a child during its infancy. Such is the special relationship of a mother with her child. And that is why, under Muslim law, she has been given a special right of hizanat. That means up to a certain age, when the child is infant, immature, the child must be under the custody of its mother. And this is the right of the mother. But her custody of the child is subject to the supervision of the father. Subject to the supervision of the father. That means while the child is in the custody of mother, actual custody is with the mother, but the supervision remains with the father because he is the legal guardian. And when he is the legal guardian, he has the obligation to provide means for upbringing of the child. That means maintenance, etc. Whose responsibility it is? It is the responsibility of the father. And where is the child? Child is in the custody of the mother. Why? Because the right of custody is with the mother. What is the name of that right? Hizanat. So hizanat remains with the mother, and vilayat-e-nafs remains with the father. Now let us try to understand the legal guardians of minor's property and their powers. Who are the legal guardians of minor's property? So far we studied legal guardianship of person. Now we are talking about guardianship of property. The legal guardians of minor's property are again father, his executor, then paternal grandfather, and his executor. The same sequence which we had earlier talked about. Under Muslim law, the only relatives entitled to act as guardians of minor's property are the father and the paternal grandfather. I'm repeating it. Earlier also I had said that only two relatives have this right, father and paternal grandfather. No other relative has the right to guardianship of minor's property. Not even mother, brother, uncle, but mother, brother, uncle, etc., other relatives may act as the guardians of the property of a minor only if they have been appointed as testamentary guardians either by father or paternal grandfather, because they only, father and grandfather, have got the right to appoint testamentary guardian. Now, what are the powers of these legal guardians with regard to the property of the minor? The property belongs to the minor. Remember, whose property it is? If this question arises, the property is of the minor. Who is the owner of that property? The minor is the owner of the property. Even if the minor is a child, even if the minor is, of course, a minor is always a child. Even if a minor is 1 year old, 2 years old, 3 years old, infant, if he has a property, he is the owner. And suppose his father is the natural guardian, the property does not belong to the father. The father is only the guardian of the property of the minor. But what can he do with the property of the minor? what kind of powers he has with regard to that property, the property which belongs to the minor. In this slide, the things will be clear. In this and subsequent slides, the things will be clear. The guardian of the property of the ward is bound to deal with it as carefully as a man of ordinary prudence would deal with his own. Let me say it in Hindi. एक सामान्य प्रज्ञावान व्यक्ति, एक सामान्य समझ रखने वाला व्यक्ति जिस प्रकार अपनी संपत्ति की देखभाल करता है, ठीक वैसे ही देखभाल करने की जिम्मेदारी नेचुरल गार्जियन की है कि वो माइनर की संपत्ति की देखभाल करे। जैसे वो स्वयं की संपत्ति की देखभाल करता है, वैसे ही वो माइनर की संपत्ति की देखभाल करने की जिम्मेदारी रखता है। वो उसे अपनी संपत्ति नहीं समझ सकता। This point must not be forgotten. And further, subject to the provisions of the Guardians and Wards Act 1890, he may do all reasonable and proper acts for the realization, protection, or benefit of minor's property. If he does anything, he can do it, provided his action is reasonable and proper. For what? For the realization, protection, or benefit of minor's property. The power of the legal guardian to deal with the properties of the minor depend upon two things. Number one, nature of the property. Number two, nature of the transfer. So these two things decide to what extent the legal guardian has the power over the property of the minor. It is decided by number one, by the nature of the property, what kind of property it is. Number two, what kind of the transfer it is, because transfers are of many kinds. I'll tell you in subsequent slides, you will come to know. The guardian's power to transfer the movable property of the minor is wider than those in respect of immovable property. In respect of this sentence says that in respect of movable property, the legal guardian has more power as compared to immovable property, with regard to immovable property. Now, let us try to understand. Suppose the legal guardian wants to sell the immovable property of the minor. Can he do so? And if he can do, under what conditions he can do? Always remember, this property does not belong to the guardian. The property is of the minor. Can he transfer that property? Now, these are the situations which are mentioned here. A legal guardian has no authority. This is the bottom line. A legal guardian has no authority to sell the immovable property of his ward, that means minor, except in the following exceptional situations. These exceptional situations are self-explanatory. My request to you is that please go through these lines. I don't want to read out. You can very well understand. Very clearly, these things have been mentioned. These are the exceptional situations. Only in these exceptional situations, a legal guardian has the right to sell the immovable property of the minor, not otherwise. Similarly, there is one more kind of transfer. This transfer is called mortgage. Mortgage. In Hindi, we call it bandhak. I hope you must have studied pledge under law of contract. When a movable property is kept as a security for loan, movable property is kept as a security for loan, this transaction is known as pledge, girvi. In Hindi, we call it girvi. But when immovable property is kept as security for a loan, then this transfer is known as mortgage. The nature of the property changes. In case of pledge, the property is movable. In case of mortgage, the property is immovable. What will happen? Can the legal guardian mortgage the minor's property? A legal guardian, the legal guardian's right to mortgage the minor's property is the same as that for the sale. What does it mean? It means that he can mortgage minor's immovable property only in those situations where he can sell. In the previous slide, I have mentioned 7 points where in those situations where he can sell. And those are exceptional situations only. When you will go through those points, you will understand. In the same situations, if there is any, the legal guardian may may mortgage the immovable property of the minor. Lease is another kind of transfer. This is also a transfer. What happens in case of lease? That the property is given for a specified period of time to a person, so that that person, lessee, may use that property and take advantage of. But in return, he makes some payment to the person who has made the lease in favor of him. So this transaction is called, this is also a kind of transfer under Transfer of Property Act. Can the legal guardian lease out the immovable property of the minor? The answer is, under certain circumstances, he can. The legal guardian is authorized to lease out the property only if it is for the benefit of the ward. That is minor. Ward means minor. The guardian is authorized to lease out the property only if it is for the benefit of the ward. However, the lease must be for a term not exceeding the minority. It cannot be for a very long time. Beyond the minority, the period cannot go. What does it mean? Someday the minor becomes major. One day the minor will become major. When will he become major? The moment he becomes 18 years old. The moment he becomes 18 years old, he will be a major. So for how long the legal guardian may lease out minor's immovable property? Till the time when the minor becomes major. It cannot go beyond that period. So these are the limitations. Now, transfer of movable property by legal guardian is concerned, the legal guardian has got more power as compared to immovable property. Under Muslim law, the legal guardian has the right to deal with the movable property of his ward. The guardian is authorized to sell, pledge or pawn the movable property for the minor, provided it is urgently required in the interest of the minor. Provided, I repeat, it is urgently required in the interest of the minor. For example, minor's fooding, clothing, nursing, etc. As far as the powers of testamentary and statutory guardians are concerned, the testamentary guardians are substitutes of legal guardians. They are substitutes of legal guardians. Therefore, their powers are the same as those of the legal guardian. What the legal guardian can do, the testamentary guardian can also do, because he is a substitute of the legal guardian. That means natural guardian. So what natural or legal guardian can do, testamentary guardian can also do, because he is only a substitute of legal or natural guardian. And what about the guardian appointed by court? The guardian appointed by court has no authority to deal with minor's property without the previous permission of the court. He needs previous permission of the court. Only because he is a guardian of very limited power. He works under the supervision of the court. So if he wants to sell the property, if there is any situation, then he must first of all seek the permission of the court. If the court permits, then only that property can be transferred or sold. The powers and duties of the guardians appointed by court are governed by Guardians and Wards Act 1890. You know it very well. I have already said. As far as the de facto guardian is concerned, de facto guardian has got very limited power, very limited power. He cannot sell immovable properties. However, in certain situations only, he can sell movable properties only and not otherwise. So that's all I had to tell you about guardianship. I hope you have understood it. You should go through it and you should read your book also on the subject. Then you will be able to comprehend the entire discussion. Thank you very much. Thank you.